Hi guys, it's Kathy. I hope you're doing well. We made it to Friday. Yes, Friday. I didn't get to look to see because my eyes bothering me again. And it's real tiny. Who called me? But thank you, Kelly. I'm gonna say thank you, Kelly. Thank you, Monica. I did go out after work last night. It was my. I didn't. I came home, and then I did some work, and I went to bed, and then I got a call. Hey, Kathy, do you want to go out? Yes. I should have said no, and I said yes, and it was great. We watched football. We drank beer. Yeah, it was a good night. It was a good night. Bobby, that is a question, isn't it? Because, like, first off, who else could be Kathy? And then, second off, who would I be if I'm not? Who would I pick? Can I be you, Bobby, for a few days? I'll only slightly touch your bank account. See? See, if a woman wants to be someone else for a few days, they pick a man and talk about their bank account. If a man wants to be someone else for a few days, they absolutely pick a woman. They don't talk about the bank account. They talk about other things. I can't. People are calling me. I don't want to talk to you, Kelly. Yeah, but what if I didn't have hair, Bobby? Would as many people watch? Because it really shouldn't matter if I have hair or not. This is a court channel. Does it matter if I have hair? What if, let's say, I purposely chose bald to show support to someone else? Would that be a bad thing? What if I purposely got rid of all of my hair to be twins with someone else? Yes, Linus. That's what I'm talking about, Linus. That's exactly what I'll do, Linus. I don't know. I'm just going to press play on. We're going to go to Jersey. And I know, but Bobby, I really want to. I want to so badly you don't know. Yeah, see, I could wear a bandana. I could wear a raspberry beret. I could wear a wig. Or not. I could wear none of those things. Because it's fine just the way it is. I don't have to cover it up. But I do have a mustache and beard, Bobby. I just have to keep plucking it. Yeah. Women do. Women do. We just do. Wow, I don't want to mess it up. Linus might be going bald soon. And I would shave my head if that would make her going bald any better at all. Because she has to go through chemo. Cancer sucks. Linus, we are all here for you. You just tell us what you want at any time, and we will be there for you. Yes. See, Bobby, you didn't think about that. It grows right back in a little bit. It grows back. I don't know if you were here back then, but I had real short hair when I first put my camera on for when I was streaming, because I had a medical thing that I wanted to, and I'm a server. So servers have to wear their hair up in a ponytail. Well, I didn't want anybody to see my neck. So I cut my hair shorter length. So I never had to put my hair up. And it grew back. It always grows back. Yeah, Terry. Yes, Terry. All right, we're gonna go to Jersey because he has a bruise. This poor man, this very strong man, got a bruise right here. It looks like a healthy bruise too. I don't know what happened. I didn't see it. But I'm trying to figure out what made that bruise, okay? We got, he's the one in the booth. So he's the one, he's the criminal here, allegedly. We should try to guess what. Here's my guess. And I'm probably way wrong. Alright? I don't know what they're called. But police have these guns that shoot these little, are they like sandbags? Where's Josh when you need him? Josh would help me get over this bridge that I'm at right now. Not a paintball, but they salt, are they salt shotgun? I'm this close, guys. I'm this close. But police have these guns that shoot these salt bags or something like that. I don't know. Because it's so round. I feel like it's not someone hitting him, kicking him, biting him, headbutting him. I don't know. Beanbag? Salt bag? I think it has the word salt in it. Beanbag? Okay, beanbag. He got hit by a beanbag. That's my guess. And here's the problem, guys. We might not find out, because this is right where it starts. But fingers crossed that's that we find out what it is at least. What else could it be? No one else is guessing how he got injured. Gosh, he's so like big. Who would hit that part? Let's see. Let's press play.
So, Judge, again, that's a situation that police.
No, a bite.
I mean, if that happened to me,
Oh.
I'd be upset about it. You can just. These are DP level.
Let him go. That is self-defense. I don't care what he did to her. I understand he's way bigger than her. She bit him. She bit him. He's allowed to defend himself.
Offenses. And the purpose of the Criminal Justice Reform Act, the very purpose of it, is to have more people. Measure to detain someone.
All right.
So, Judge, again,
54 seconds. I turned it
that's
back.
a situation. It's like a he said, she said. He's flashing the bruise that he received, I guess, from the bite mark that he showed the police at the time of the incident. I mean, if that happened to me, I'd be upset about it. You can just, yeah, there we go. Again, Judge, these are DP level offenses, and the purpose of the Criminal Justice Reform Act, the very purpose of it, is to have more people at liberty to defend against charges for which they're presumed innocent, rather than having more people incarcerated. Again, it's a drastic measure to detain someone pre-trial. Mr. Thomas, he doesn't live with either of these alleged victims, so therefore there's no reason for him to have contact with them.
Chinny, you're right. In what circumstance would she bite him there? Her head would have to be back here, or his arm would have to be in. Okay, if I'm down on the ground and his arm is on me, hell yes, I'm biting him. I'm taking skin with me. I'm not leaving a bruise. So, who knows what happened? Because that's a weird spot. Chinny's right. Like, if she's going to bite someone during an argument, they're facing each other. This is behind him. So, unless he turned to walk away and she ran and bit his arm, and that it makes sense because he's probably much taller and that's where her mouth would be. It also makes sense if she's on the ground, they're fighting, and this is right over her mouth. That makes sense too. We'll never know because she's not here. Maybe she's here. I don't know.
He can abide by a no contact provision in a release order. He's lived all his life in this community. He's got several kids. He provides support to all kids. He graduated Bridgeton High School. He works at LJ Azuka as a dock worker, unloading trucks. He's been there for the last 6 months. I don't see.
Yep, Kelly. Yep.
In his history at all. Well, there is the prior drug distribution charge from 2013. That's a long time ago. So otherwise, I don't see an indication in his history that he is an addict of any sort, which would, again, oftentimes drives a person to have unwanted contact with the criminal justice system and to not be law abiding. We don't see that in this case, Judge. I think that there are plenty of tools at Your Honor's disposal whereby this individual, again, these are DP charges. If they were not DV related, Your Honor could not even impose a pretrial detention on him. So I would just ask that you release him with conditions, Judge.
Thank you. Anything further, Ms. Zirkle?
No, Your Honor, thank you.
Right, after considering the evidence and the arguments of counsel, I find that the state has not met its burden to prove by clear and convincing evidence that no amount of monetary bail, non-monetary conditions, or a combination
Sir,
of all.
Nobody wanted a cracked shot. Cracked shot. That's hard to say. How dare he? People in Jersey are just different.
Or a combination of both would reasonably assure the defendant's appearance in court when required, the protection of the safety of any other person in the community, or that the defendant will not obstruct or attempt to obstruct the criminal justice process. I have considered the PSA recommendation that recommends no release. Just a moment. I considered the PSA recommendation of no release. But I find the following factors are significant in this case. The defendant was not on probation, parole, or pretrial monitoring at the time of this offense. And just to be clear, this
Hi, Violet.
motion is brought with respect to only the October 14th, 2024 offense allegation on warrant 1233. The offense charge is a disorderly persons offense. He had no pending charges at the time of this offense. He has 2 prior disorderly persons convictions and 2 indictable convictions. The indictable convictions are remote. The CDS conviction is from 2013 and the theft conviction is from 2008, both third degree.
I hate when it does that. So sometimes I chat as Laugh Vibes because, well, I don't know why, but because, so like, I have a couple like channels that do nothing so that I can store court content. I can go live. I go live on them every single day, unlisted. You can't see them. This, what we're watching, is court that I had on this Laugh Vibes channel that I never, ever, ever use, ever, for like people. I don't upload content to it for people. When I sign into Court Vibes, every once in a while, my chat will open to one of my other stupid channels, and it just is a little complicated to fix. So I'm just gonna leave it like that. It's stupid. YouTube is stupid. But we already knew that. I'm sorry if it's confusing.
Crimes. He has 1 prior violent conviction, which is a disorderly persons conviction for assault. He has no prior failures to appear in the past 2 years. And his prior sentences to incarceration are remote from 2017 and 2011. The defendant does reside locally. He is employed, has been employed by the same employer for 6 months. So although there is some concern about recent violent charges, the most recent was charged on a summons as a disorderly persons offense. He has no indictable violent convictions. With respect to the domestic violence restraining orders, all of them have been dismissed, and none of them resulted in a final order. So I find that they cannot be given weight with
They
respect
can
to
be given weight.
the court's determination. So for all of those reasons, I find that there are adequate conditions that the court could order. In addition, I do find it significant that the allegation in this case was that it occurred in October of 2024. And there is no evidence that the defendant has had any contact with the victim or any unlawful contact with the alleged victim since that time. And I do find that to be significant as well. So I find that the condition of no contact with this victim would be sufficient as well as other conditions that could be and will be ordered by the court to ensure the defendant's appearance in court and the protection of the safety of any other person in the community. I will order that he be released on the following conditions: that he not obtain any new offenses, charges, that he not have any contact with the alleged victim in this case, referenced in the complaint as KM. And her name is in the report that's in evidence. In addition, he is not to possess any firearms, destructive devices, or dangerous weapons. I'll require him to report to pretrial services on a
Monica, thanks for the cheers. Thank you, thank you. Hi, Kelly.
I'm going to require a level 2 reporting, which is 1 phone contact and 1 in-person report monthly. And that is on the basis that he is currently employed. And so that will reduce the numbers of times that he would have to report in person, while also ensuring that he gets regular and frequent reminders of his court dates and is checking in with pretrial services regularly.
Kelly, thanks for the cheers. Thank you.
He is required to notify pretrial services of any change in his address or other contact information. He shall not use or possess illegal or non-prescription narcotics, not use alcohol to excess. He shall appear for all court proceedings. And he shall maintain employment. We do have his contact information. His next proceeding is January 6, 2026. And he's to report to pretrial services by 2 p.m. tomorrow by phone. All the contact information and release conditions will be set forth in an order that will be given to you, sir, upon your release. It's important that you read it, that you comply with the pretrial release conditions. The state in this case asked for you to be detained. I did not grant that, but if you violate the conditions of your release, the state could file a motion to revoke your release, and you could be detained if you violate the conditions. Do you understand, sir?
Yes, ma'am.
Is there anything further for this case?
Can I ask one question?
Yes, Mr. Thomas.
I have another case. It's like under $1,000. It's like $100 for out of Atlantic City that they
That's
booked me on.
not
today.
something I can address here. Not something I can address here. Yeah, you can contact your attorney. You can might be able to help you with that.
Whoa, what? What did he just say? Okay, that doesn't make sense. We're in New Jersey. Atlantic City is in New Jersey, right? So in New Jersey, there's no bond amounts. They don't give bonds in New Jersey anymore. Now, some cases are grandfathered in where they had set a bond in the past, and the case is still going, so there is a bond there. It's either so you get arrested and you go in front of a judge, okay, and they either detain you or release you. Those are the 2 options. The way you get detained is the prosecutor says, I want them detained. If the prosecutor says during that initial hearing, I want them detained, nothing. Not even the judge can say, no, we're letting him go or her go. That person must stay in jail, right? And then they go in front of a superior court judge, usually within a couple days. And then the superior court judge hears why they're being detained and decides then, okay, you are going to stay detained or we're going to release you. Those are the only two options. If they get released on conditions. And there's different levels. Level 1 is the highest, where you have to contact probation twice a week or go in once and call once. And then level 2 would be like you have to call 1 week and go in the next week. And level 3 is call once a month. So you have levels and you have different conditions in those levels. But there's no bond amount. There's no money. He just said he had a case in Atlantic City, which is New Jersey, and it has $100 or $1,000 on it. That doesn't make any sense. I don't understand that. Unless, okay, I don't get Atlantic. Do I get Atlantic City? Did I ever do Atlantic City? I did. We do Essex all the time because Nakama is there. By the way, you can only see New Jersey courts on this channel. Ha! Yesterday, Judge Michael Fish, only this channel. Today, I don't know her name. I can't read that because my eye. Only this channel. But she's boring, so I'm not getting her again. Cumberland County, I think that's what it says. I don't know where Atlantic City is. I wonder what county Atlantic City is in. I might get Atlantic City and not even know it. But if I can find out what county Atlantic City's in, we are getting them because we're going to find out if they give cash bonds. Which is weird because nowhere else in New Jersey do we see cash bonds.
If there's
No, I just
something else
know, but
detaining,
I might
if
not be
there's,
able to report. I might not be able to report to the pretrial service tomorrow because of that. That's what I'm trying
Okay.
to say.
okay, I understand. If you can't report because you're still detained on some other matter, then that's fine. You can't report. You can't report. But as soon as you are released, if you are released on that other matter, you're to report to pretrial services by within the next business day after your release by 2 p.m. Do you understand?
Okay. Yes, ma'am.
Okay, you're free to leave the booth at this time.
Thank you.
Congratulations
Thank you.
on another streak, Kelly.
Thank you, sir.
Twitch. Hopefully it stays, but people lose, so don't get your heart on it. But we're going to do our best to keep it going.
Hello, can you please tell me your name?
Dante Holt.
This next case is State versus Dante Holt on warrant 2025-1224610 and warrant 2025-1492610. Counsel, your appearances, please.
More, Your Honor, April Zirkle on behalf of the state.
Nathan Perry, Officer Counter for Mr. Holt.
Matter scheduled for a detention hearing today. Is the state ready to proceed?
Your Honor, the state is going to be asking for a 3-day adjournment in order to get further discovery.
Any objection from the defense?
Well, Judge, I don't really have the ability to object. The state has the right to request that postponement concerning, according to the laws and rules that govern these types of proceedings. So,
Morning.
Obviously, we don't have an objection.
I see that you wrote a novel.
Okay.
Have a seat.
Excuse me.
Yeah,
All right,
it's
Mr.
nice.
What is happening at this
Meaty,
time is that the
does
state is
that.
asking for
She
more
texted
time
so
to
it's
prepare for the
always Christmas
hearing.
when she does that.
The state is entitled
We put
to
the tree
up
and
to
then
3
she,
days
over weekend.
to adjourn the
does
matter
that,
so that it can prepare for the hearing.
okay, so
That sucks. Hold on, I'm going to fast forward a little bit and see if we still have 2 courts. Wait. I want to see what's going on there. What was that? Oh, he's holding up something. Let's see if there's still 2 court. Is that the same guy? Oh no, this is a real long one with stuff happening and it recorded badly. Son of a gun. Hold on. Let's just go here.
397,
With the
12, and
defendant
what?
picking up.
Son of a gun. Son of a gun. I'm so mad right now. You don't even know. I have to get something else on for you real quick because this recorded badly. Son of a gun. Don't worry, I got plenty of other stuff. We just can't do Jersey today. Let's go to probably Colorado. I can't remember if I did this or not. We're going to go to Georgia. If I already did it,
Default after that. So it would seem out of turn.
Judge Caulfield had an echo. It wasn't me. It was him. I know because I went to a couple different devices and I went to his courtroom and he had an echo. It's not bad, but it's bad enough that since I just messed up this, I don't want to give you an echo. So we are going to Denver, Colorado now.
Number 15 is 24 CR 5229, People versus Emmanuel Gatate.
Sammy, what's for the people?
Nicholas Weber, Office of Public Defender. Just as a courtesy, I was speaking with alternate defense counsel Mark Burton. Sounds like I just need to make a record about the conflict because of the lengthy FTA. The conflict still persists with our office, and so I just wanted that noted in the minutes so that Mr. Burton can get done what he needs to administratively over with ADC. It looks like the listed co-defendant, it still has an active case with our office.
Thank you. The defendant is not here. He's in custody. He's just not here.
Right. I just wanted to, while we had a moment, address
The
that.
Public Defender's Office notes, as indicated, their conflict is ongoing. I will appoint the Office of the Alternative Defense Counsel, Mr. Burton. Thank you.
Thank you, Judge.
And Your Honor, if you could call number 58, Mr. Shaw. It's the Lincoln County.
Is Karen Fitzgerald someone who should be here? 58 is 25 CR 5146, People versus Devin Shaw.
Sam Hamowitz on behalf of Kim Falone for the people.
And Sean McCarthy for Mr. Shaw, who was in the virtual courtroom. It seems like he just disappeared.
It's going to be back in just a moment.
Oh, there we go.
Mr. Shaw, can you see and hear me?
Yes, sir.
I just called your case. The people just entered, your lawyer just entered his appearance. Under Rule 43, you have a right to be here physically with your lawyer in the courtroom. Do you waive that for today's hearing?
Yes, sir.
Mr. McCarthy?
Your Honor, a couple things to address. So Mr. Shaw, my understanding is that he was on probation in New Mexico. He transferred it through the Interstate Compact to Nebraska. They filed a petition to revoke based on these new alleged law violations. I think he will remain in Nebraska. He has a court date today to see what happens as far as extradition goes. But my request would be twofold. One, to set this arraignment over so that I can get some more information about the New Mexico probation violations. I think my request would be, if possible, that he is extradited. I think Ms. Falone and I were discussing this case, but we did not have a disposition to present to the court today. And that disposition may change if this probation violation results in incarceration for Mr. Shaw.
First, let's talk about the bond. Does something need to happen? Is he being surrendered on his bond today?
Your Honor, I think our request would be, I think, maybe to self-revoke the bond and send the $250 back to his mother. I did confirm that the address listed on the bond is still her address. I think I would argue she made some efforts to make sure that Mr. Shaw was in court today, at least virtually.
Is she here?
She is not. I'm happy to reach out to her and see if she would be willing to log into the virtual courtroom.
I don't know that she needs to. Well, actually, he posted his bond, or Devin, is his name Devin J. Shaw?
Yes.
He posted his own bond, so he can self-revoke his bond today if you'd like.
And that would be our request.
I will revoke your bond, Mr. Shaw. $200 will be mailed back, $250 will be mailed back to 313 West Phillip in North Platte, Nebraska. What is the area code there?
69101.
That may need to be provided to the bonding office.
I can do that.
People's position on continuing arraignment.
No objection from the people.
When would you like to come back?
Your Honor, my preference would be January 15th or 16th.
I think only the 15th.
16 is bad, 15 is okay.
People can accept the 15th.
He may be in New Mexico.
Your Honor, it's possible that he is extradited. I think that if my request would be a virtual writ to the Lincoln County Jail, because that's where he is now. If that changes, I've asked I'll keep a tab on it, and his mother also will reach out and let me know. So if we need to change that writ, I will.
Yes, sir.
Continue this for arraignment to Thursday, January 15, 2026, 8:30 in the morning. Virtual writ to the Lincoln County, Nebraska Jail in North Platte, Nebraska. I do need to reset bond. What are your thoughts on new bond?
Your Honor, I think that the court could issue, again, a $250 cash bond. I think that is appropriate.
For the people?
People would ask for 5,000 cash property surety.
Are you able to see his pretrial services bond advisement report? I can't open it.
I am, Your Honor. I have to approach
What is this CPADR?
unable to score, unable to interview.
Prior felony convictions?
It looks like one out of Washington. And it is listed as a burglary. In speaking with Mr. Shaw, I understand that he pled it down to a misdemeanor with some community service, but on the bond report, it does show as a felony out of Washington.
I'll set bond in the requested amount, $5,000 cash surety property. What else can we talk about today?
Nothing at this time.
Nothing from the people.
Thank you, and thank you to the deputies in Lincoln County.
Thank you, sir.
Mr. Shaw, I'll talk to you soon, ma'am.
All right, thank you.
Mr. Lozo, good morning.
Good morning, Your Honor. How are you?
I'm fine, how are you?
Good to see you.
Good to see you.
May we call number 3, please, the Barella matter?
3 is 25 CR 3618, People versus Evanaya Barella.
Josh Nathaniel for the people.
Your Honor, Brad Lozo appearing on behalf of Ms. Barella. She appears by my side on bond.
Good morning, Ms. Barella. Here on arraignment today, I saw paperwork filed on December 9.
Right before we go forward, I fully anticipated disposition. May we set it over so I can clarify that one issue, Your Honor?
Oh, I understand what you mean. Mr. Nathaniel.
No objection to a continued arraignment. The offer will remain open. We can accept any date that works for the court and counsel.
When would you like to come back, Mr. Lozo?
We can come earlier if the court offered. I couldn't do the 15th or 16th, the 22nd or 23rd. If the court has the days earlier, I can look too.
23rd is a good day. January 8 is a bad day. January 2nd is a good day. That's a Friday. You want to come the week of New Year's?
Why do we do the 23rd, please, Your Honor?
Mr. Nathaniel,
That works. Thank you.
your bond, PR bond, in this matter continue for arraignment Friday, January 23rd, 2026, 8:30 in the morning. What else?
Thank you, Your Honor. Have a happy, healthy new year.
Thank you, Mr. Loza.
Thank you.
What date was that? I'm still.
23rd
Thank you.
of January. Ms. Dixon, you just sent a note. You're here on Mr. Robles.
Good morning. Yes, Your Honor.
Yeah, thank you.
Yeah, sure thing. You as well.
Thank you. I just worried about you.
You're good.
Number 56, right? Yes. Thank you. Karen Fitzgerald, are you here for court today?
Yes, I'm here for Gutierrez.
Thank you. Who's next?
Morning, Your Honor.
Good morning.
Could we call Mr. Reyes Lopez? It's 25 CR 3101.
51 is 25 CR 3101, People versus Michael Reyes Lopez.
Josh Nathaniel for the people.
And John Buchanan on behalf of Mr. Reyes Lopez appearing out of custody to my left.
Mr. Bushenik,
Yes, sir.
what's your registration number?
57071. And I'm covering for Mr. Marinoff, who's on the case.
Thank you. Mr. Reyes Lopez, good morning.
Good morning.
You're for arraignment today. How would you like to proceed?
We'd like to enter the plea agreement that we have negotiated with the people and filed with the court.
I saw paperwork filed on December 11, 2025. The disposition is?
Judge, Mr. Reyes Lopez will be pleading guilty to an assault in the second degree. It's the strangulation subsection. I think it's subsection 1I. There is a waiver of Blakely, which would get the potential sentencing range at the top end up to 16 years. And there's a stipulation that if the defendant is sentenced to the bottom range, the floor would be 5 years. So he would be facing 5 to 16 years in the Department of Corrections. It's probation eligible. It's community corrections eligible. We would ask for a PSI.
Has the added count 4 been filed?
If it is not, I apologize and I will file it right now.
Is that correct?
Yes, that's correct, Your Honor.
Mr. Reyes Lopez, we're going to have a conversation about what the lawyers just told me. Speak right into that microphone. Start by saying your first and last names.
Michael Angel Reyes Lopez.
Are you the defendant charged in this case?
Yes.
How old are you?
21 now.
How far have you gone in school?
12 years.
Do you read and understand the English language?
Yes.
Are you thinking clearly today?
Yes.
Are you under the influence of any street drugs or alcohol?
No.
Have you consumed any pill, drug, or alcohol the past 24 hours?
No.
Do you suffer from any mental or emotional condition that makes it difficult for you to understand what's happening in court?
No.
The disposition, as I understand it, is you'll plead guilty to an added count 4, assault in the second degree. That's a class 4 felony. Your agreement contemplates open sentencing. You are probation eligible. You are waiving the requirements of the Blakely decision. Therefore, you could be.
That makes sense, Bobby. They still have bond in Jersey, but not the primary use. Except I've not seen it. I've not seen anybody getting a bond ever. They all get detained. They all either get detained or not. But I mean, I did see, you know, like some cases where there was a bond and the judge is like, yeah, your bond was grandfathered, but I have not seen anybody get a new bond in a long time. We're watching now Denver. They give bonds all the time, like candy.
Sentenced to either the Department of Corrections or Community Corrections for up to 16 years. If you are sentenced to either the Department of Corrections or Community Corrections, the stipulated minimum is 5 years. Could get probation, but if you are sentenced to either Community Corrections or Department of Corrections, the range is 5 to 16 years. Is that your understanding of the disposition?
Yes, Your Honor.
Is that how you want to proceed today?
Yeah.
Have you had enough time to speak about this with your lawyers?
Yeah.
Are you satisfied with their representation?
Yeah.
Added count 4 says assault in the second degree, class 4 felony on November 23, 2023. Michael A. Reyes Lopez, with intent to cause bodily injury to another person, unlawfully and feloniously applied sufficient pressure to impede or restrict the breathing or circulation of the blood of William C. Malpica by applying such pressure to the neck or by blocking the nose or mouth and thereby caused bodily injury in violation of the law. With respect to added count 4, what is your plea, guilty or not guilty?
Guilty.
Are you a member of or a veteran of the United States Armed Forces?
No.
Before I can accept your plea, I need to make sure you understand certain rights that you have and the effect of your guilty plea on those rights. You have the right to be represented by an attorney, not just today, but at any proceeding that would be held in this case, up to and including trial. If you were indigent, if you could not afford an attorney, one would be appointed for you by the court at no cost. You have the right to a speedy and public trial, which must be held within 6 months of the entry of your plea of not guilty. At trial, you would be presumed innocent. You would not have to prove anything. The district attorney would have to prove your guilt as to all the elements of the charged offense beyond a reasonable doubt to a unanimous jury of 12 at trial. You'd have various personal rights. You'd have the right to testify. You'd have the right not to testify. You'd have the right to choose whether or not to testify. You'd have the right to present evidence and call witnesses, including asking the court to issue subpoenas for witnesses and documents. You'd have the right to confront any witnesses called by the district attorney, to cross-examine them and ask them questions. If you were convicted at trial, you'd have the right to appeal to a higher court. Do you understand all those rights?
Yeah.
Do you understand that by pleading guilty today, you give up all those rights, there won't be a trial?
Yeah.
The lawyers have given me several documents. The first one is captioned. The defendant's request to plead guilty, Crim P. Rule 11 guilty plea advisement has the initials MR along the sides of pages 1 through 7. A signature above the line for your name, the date of December 11, 2025 at the bottom of page 10. Are those your initials and signature?
Yes, Your Honor.
Did you have a chance to review? It is not signed by either Mr. Marinoff or Mr. Bushenik. Did you have a chance to review this document with your attorneys?
Yeah.
Were you able to ask them any questions that you had about it?
Yeah.
By signing, initialing, and dating it, does that mean you read and understood what it says?
Yeah.
Mr. Bushenik, did you review this document with your client?
Yes, Your Honor, as did Mr. Marinoff. I don't know why he didn't sign it before he filed it, but I'd be happy to authenticate for the record.
Thank you. The second document, 2 pages long, it's captioned elements, assault in the second degree, class 4 felony, is above the line for your name. It doesn't look like the signature that appears above the line for your name on the other document. Dated December 11, 2025. Did you have a chance to review this document with your attorney?
I'm pretty sure, yeah.
Did you print your name on this
Yeah,
document?
I'm the one who did it, yeah.
That's your handwriting? Do you need a chance to look at this to make sure it's the right document? It looks like Mr. Nathaniel may be able to help you out.
Just give me my computer, just go through it.
Okay. All right, so these are what it's talking about.
Judge, I've handed the e-file document to Mr. Reyes.
Thank you.
Oh, I just printed my name.
Yeah.
Oh.
Okay, so you just asked him for that.
Oh.
Because it's not, doesn't.
Yeah. Yeah.
Did you print your name above the line that says defendant?
Yeah, Your Honor.
Did you have a chance to review this document with your attorneys?
Yeah.
Were you able to ask them any questions you had about it?
Yeah.
By writing your name on the document and dating it, does that mean you read and understood what it says?
Yes, Your Honor.
Do you admit that you committed the offense listed in the elements, and are you waiving the requirement of the district attorney to prove those elements beyond a reasonable doubt to a unanimous jury of 12?
Yeah.
In signing both these documents, do you understand you're waiving any defenses you may have had to this charge?
Yeah.
You're subject to certain penalties as provided by law for the Class 4 felony. It's extraordinary risk, is that correct?
It is. So it's, in the presumptive, it would be 2.5 to 8.
However, he's waiving Blakely. The
And
range is 5 to
stipulating-
16.
Yes, and stipulate to a floor of 5.
You're pleading to an extraordinary risk crime, however, because you've waived the requirements of the Blakely decision, the sentencing range 5 to 16 years in the Department of Corrections. If you're sentenced to community corrections, it could be between 5 and 16 years, but you are probation eligible. There is a 3-year mandatory parole period, a fine of $2,000 to $500,000. Do you understand the possible penalties for this offense?
Yeah, Your Honor.
Other than the disposition we've discussed, if any other promise has been made to you to get you to plead guilty?
No.
Is anyone forcing you or pressuring you into pleading guilty?
No.
Is your decision to plead guilty your own free and voluntary decision?
Yes, Your Honor.
As to factual basis,
Waived, Your Honor.
do you have questions for me about your plea?
No.
Is this still what you want to do?
Yeah.
I'll note the court's file reflects Rule 5 advisement. Anything further on the plea?
Nothing from the people.
On the plea?
Nothing on the plea specifically, Your Honor. I just wanted to make sure that we had addressed the continuance of bond. We do have consent of the surety to carry over.
Intelligently and voluntarily. Judgment of conviction enters on added count 4. Counts 1, 2, 3 are dismissed. PSI?
Please.
Well,
Please, Judge, and I don't see the victim present online. He wasn't in favor of this offer. I'm VRA compliant for this, but I just wanted to make that record.
So I have not seen Mr. Malpica or Mr. Navarro Acevedo in the virtual courtroom. Are they here in the physical courtroom? We'll order a PSI, your first best option, January 29 or 30.
The people can't accept any date.
Say the 29th or the 30th, Your Honor?
Thursday or Friday.
Okay, let's go with the 30th.
Morning or afternoon?
Afternoon of January 30th looks open.
Afternoon's a good idea.
Continue this for sentencing to Friday, January 30, 2026, 1:30 p.m. PSI is ordered. Then we should talk about the cash bond that Ms. Lopez Cardona posted.
Yes, I just wanted to make sure that the bond could continue between now and sentencing, and she is present.
Ms. Lopez Cardona, are you here? Would you please come up to the front of the room? Pull that microphone down and say your first and last names.
Virginia Lopez Cardona.
Are you the surety on Mr. Reyes Lopez's bond?
Yeah.
Do you consent to stay on his bond, the $500 that you posted, until January 30, 2026 at 1:30 p.m.?
Yes.
With consent of surety, I will continue your bond, this matter for sentencing, January 30, 2026, 1:30 p.m. What else?
Nothing from the people.
Nothing from the defense.
Mr. Reyes Lopez, you're ordered to report to the probation department to set up your pre-sentence investigation interview. There may be cards in the top of the podium with that exact location. You just go across the streets. They may want to talk to you now. They may set up a time for you to come back later. Your success here all starts by reporting today. So you want to go right across the street and do that right now. Do you have any questions?
No, Your Honor. Thank you.
Thank you, Mr. Reyes Lopez.
Thank you.
Thank you. Who's next?
And Your Honor, I know we sometimes have issues with DOC and Mr. McCaslin. Mr.
Sure.
Gardner's here and we're ready to go.
Yes, let's do the DOC matter. 33 is 21 CR 5877, People versus Johnny McCaslin.
And good morning. Thank you, Judge. Josh Raz for the people.
Morning, Mr. Raz.
Morning. Jason Gardner, behalf of Mr. McCaslin. He does appear by WebEx from DOC.
Good morning, Mr. Gardner. Good morning, Mr. McCaslin.
Good morning.
You have a right under Rule 43 to be here in the courtroom together with your lawyer in person. Do you waive that for the purposes of our hearing today?
Yes.
It's correct that a plea is going to enter today?
Judge, that's correct. I can,
Before we go any further, Mr. McCaslin, we'll see how things go here, but I'm likely to accept your plea today. I think that I want to just be clear that if you want to do this in person under Rule 43, we would writ you in and you would be able to stand next to your lawyer in court to do that. Are you waiving that right today?
Yes, sir.
Are you thinking clearly today?
Yes.
Are you under the influence of any alcohol, drugs, or other medication?
No.
We'll find a knowing, intelligent, voluntary waiver of your rights under Rule 43 to appear here in person. Mr. Raz.
I apologize, Judge. We have worked out a plea resolution, Judge, just for the court's clarification in terms of credit as outlined in the Rule 11. The calculations that defense counsel and I came to was 1,790 days from January 23rd of 2021 to today. But I would also tell the court we are VRA compliant. The victims are in agreement with this plea offer and resolution, and we would ask the court to accept it.
The disposition is?
Thank you, Judge. Mr. McCaslin will be pleading to count 1, a crime of violence, as outlined in counts 1 and count 5 in the original complaint and information. He will be sentenced to 16 years in the Department of Corrections on that count. He will also be pleading to counts 2 and 6. Again, criminal attempt to commit murder in the first degree, a crime of violence. He will be sentenced to 16 years on that count as well. Counts 1 and 5 will run consecutively to counts 2 and 6 for a total of 32 years in the Department of Corrections. That sentence will run concurrently to Adams 21 CR 279. And again, Mr. McCaslin will receive credit for 1,790 days.
Mr. Gard?
That sounds accurate.
Mr. McCaslin, we're going to have a conversation about what the lawyers just told me. At any time during...
My only question about what the lawyer just said was, this is the part that I have a problem with. He got X amount of years. I can't remember if it was 13 or 18. Let's just pretend it's 18. All right? Just for now. We're just pretending he just got 18 years in jail. But then the lawyer said, this sentence is to run concurrent with the Adams sentence that he has. I don't know what the Adams sentence is. It doesn't matter for why I'm confused. Let's just pretend the Adams sentence is 5 years. Okay? Why would this judge get to choose whether his sentence is concurrent on another judge's sentence? Like, I just think that if that other judge knew that he was going to get a murder charge and it was going to, run concurrent to his sentence, would he have still just did 5 years, or would he have changed his mind and done something different? Like, why does a judge get to run his sentence concurrent with another judge's sentence? They shouldn't be allowed to do that, right? Because that's not their jurisdiction. You would think that they can only run consecutive, and they can build their sentence around that consecutive time.
During this conversation, you cannot hear or see me. Will you please let me know?
Yes, sir.
Start by saying your first and last names.
Johnny McCaslin.
Are you the defendant charged in this case?
Yes.
How old are you?
53.
How far have you gone in school?
12 years.
Do you read and understand the English language?
Yes.
Are you thinking clearly today?
Yes.
Are you under the influence of any street drugs or alcohol?
No.
Have you consumed any pill, drug, or alcohol in the past 24 hours?
No.
Do you suffer from any mental or emotional condition that makes it difficult for you to understand what's happening today?
No.
The disposition, as I understand it, is you would plead guilty to original count 1, criminal attempt to commit murder in the first degree. That's a class 2 felony. You would also plead guilty to count 5, crime of violence, as a sentence enhancer related to that count. You'd plead guilty to original count 2, criminal attempt to commit murder in the first degree, a class 2 felony. You would plead guilty to count 6, crime of violence, which is a sentence enhancer related to count 2. On each of counts 1 and 2, you'd be sentenced to 16 years in the Department of Corrections. With 5 years of mandatory parole. Those would run consecutively to each other. You would also be, both those sentences would run concurrently to the sentence you're serving in Adams County 21 CR 279. You have 1,790 days of credit against the 32-year sentence. Is that your understanding of the disposition?
Yes.
Is that how you want to proceed, Gardner?
Yes.
Are you satisfied with his representation?
Yes.
That just feels like one judge is overruling another.
Count 1 says criminal attempt to commit murder in the first degree, class 2 felony, on or about January 23, 2021, by engaging in conduct constituting a substantial step toward the commission of murder in the first degree, Johnny R. McCaslin unlawfully, feloniously, after deliberation, and with the intent to cause the death of a person other than himself, attempted to cause the death of Noel Rodarte Ortiz in violation of the law. With respect to count 1, what is your plea, guilty or not guilty?
Guilty.
Count 2 says criminal attempt to commit murder in the first degree, class 2 felony, on or about January 25, 2021, by engaging in conduct constituting a substantial step toward the commission of murder in the first degree, Johnny M. McCaslin unlawfully, feloniously, after deliberation, and with the intent to cause the death of a person other than himself, attempted to cause the death of John E. DeGidio in violation of the law. With respect to count 2, what is your plea, guilty
That's
or
a
not
different
guilty?
person.
Guilty.
Count 5 says crime of violence, sentence enhancer, on or about January 23, 2021, Johnny R. McCaslin unlawfully used or possessed and threatened the use of a deadly weapon, namely firearm, during the attempted commission of, conspiracy to commit, or the immediate flight from the offense of criminal attempt to commit murder in the first degree as charged in count 1 in violation of the law. With respect to count 5, what is your plea, guilty or not guilty?
Guilty.
Count 6, crime of violence, sentence enhancer, on or about January 25, 2021, Johnny R. McCaslin unlawfully used or possessed and threatened the use of a deadly weapon, namely firearm, during the attempted commission of, conspiracy to commit, or the immediate flight from the offense of criminal attempt to commit murder in the first degree as charged in count 2 in violation of the law. With respect to count 6, what is your plea, guilty or not guilty?
Guilty.
Are you a member of or veteran of the United States Armed Forces?
No.
Before I can accept your plea, I need to make sure you understand certain rights that you have and the effect of your guilty pleas on those rights. You have the right to be represented by an attorney, not just today, but at any proceeding that would be held in this case up to the court at no cost. You have the right to a speedy and public trial, which must be held within 6 months of the entry of your plea of not guilty. At trial, you'd be presumed innocent. You would not have to prove anything. The district attorney would have to prove your guilt as to all the elements of the charged offenses beyond a reasonable doubt to a unanimous jury of 12. At trial, you'd have various personal rights. You'd have the right to testify. You'd have the right not to testify. You'd have the right to choose whether or not to testify. You'd have the right to present evidence and call witnesses, including asking the court to issue subpoenas for witnesses and documents. You'd have the right to confront any witnesses called by the district attorney, to cross-examine them and ask them questions. If you were convicted at trial, you'd have the right to appeal to a higher court. Do you understand all those rights?
Yes.
To understand that by pleading guilty today, you give up all those rights, there will not be a trial.
Yes.
The lawyers have given me several documents. I should say trial is set to begin on January 9, 2026. That trial would not happen. You understand that?
Yes.
The lawyers have given me several documents. The first one captioned The defendant's request to plead guilty, Crim P. Rule 11 guilty plea advisement, the electronic initials JM along the sides of pages 1 through 7. Your electronic
If they don't have a factual basis, I do. And no, he's not getting 32 years. Don't worry.
signature, the date of December 15, 2025 at the bottom of page 11. Did you have a chance to review this document with Mr. Gardner?
Yes,
Were you able to ask him any questions you had about it?
yes,
By initialing, signing, and dating this document, does that mean you read and understood what it says?
yes,
The next series of documents I've been given are captioned elements, first-degree murder, class 1 felony, elements, crime of violence, violent crime, use deadly weapon, sentence enhancement, elements and definition, criminal attempt 18-2101. There are 6 of these documents, 2 of each. Did you have a chance to review these with Mr. Gardner?
yes,
Were you able to ask him any questions you had about them?
yes,
By signing and dating them, does that mean you read and understood what they say?
yes,
Do you admit that you committed the offenses listed in the elements, and are you waiving the requirement of the district attorney to prove those elements beyond a reasonable doubt to a unanimous jury of 12?
yes,
In signing all 7 of these documents, do you understand you're waiving any defenses you may have had to these charges?
yes,
You're subject to certain penalties between s- 16 to 48 years.
Yes.
16 to 48 years in the Department of Corrections, 5 years of mandatory parole, a fine of $5,000 to $1 million. I understand you have an agreement to 16 on each count, bundling together the sentence enhancers with the substantive counts to run consecutively, but that's the most you could get for these particular offenses. Do you understand that?
that's without the habitual criminal, right?
Say that one more time.
What you're talking about is without habitual criminal, just,
The people based on this plea agreement are not proceeding on the habitual criminal counts. Mr. Razany, for the record there.
That's correct, Your Honor. The habitual counts will be dismissed pursuant to this plea agreement.
Mr. Gardner,
That's correct.
any other questions, Mr. McCaslin?
no. I just wanted to be sure on that.
It's a very fair question. Other than the disposition we've discussed, have any other promises been made to you
Hi,
to get you
another
to plead
Smith.
guilty?
No, just that I'd get pre-sentence confinement and, yeah, just, that's it. And then I would just ask, Your Honor, if, with the amount of time there is, if all the fines and stuff could be waived. If the
We're not
court-
quite there yet. Is anyone
Okay.
forcing you or pressuring you into pleading guilty?
No,
It's your decision to plead guilty, your own free and voluntary decision,
yes.
as to factual basis.
There's a waiver, Your Honor.
Here we go,
Do
guys.
you have questions for
No.
me?
No, he waived factual basis. I got you. Don't worry. Okay. He was convicted of 2 counts of first-degree attempted murder, along with multiple assault charges and violent crime enhancements. January 26th, 2021, at the Dollar General store in Adams County, Colorado, he approached 2 victims in the store and fired a handgun at them in an unprovoked fashion. The first victim was shot in the stomach and survived after significant surgery. The second victim, a woman in a wheelchair, was shot multiple times in the leg, thigh, foot, and also survived. So they had surveillance videos that got used as evidence. And that's what he did. People he didn't even know. He just shot them. One of them was in a wheelchair.
About your plea.
No,
Is this still what you want to do?
yes,
I'll note the court's file reflects Rule 5 advisement. Anything further on the pleas?
Not from the people.
On the pleas?
No, thank you.
I will accept your pleas, Mr. McCaslin. Find that they are entered knowingly, voluntarily. I'll make written findings that
Hold
they
on,
are being
Martha.
entered knowingly,
Hold on.
intelligently, and voluntarily. Judgment of conviction enters on counts 1, 2, 5, and 6. The remaining counts are dismissed. How would you like to proceed on sentencing?
Your Honor, we can proceed to immediate sentencing.
Any
That-
issues under the Victim Rights Act?
No, Your Honor, the victims are aware that this was occurring today. They were advised how to appear virtually if they chose to do so. They did not want to.
And we would like to proceed to immediate sentencing.
Waive PSI?
Yes.
Mr. McCaslin, what I'd like to do is first I'll hear from Mr. Raz, then I'll hear from Mr. Gardner. I'll give you the last word if you'd like to say anything. Mr. Raz?
Your Honor, I would just ask the court to honor the plea agreement. I think the court's well aware of the history and the facts of this case. I don't think I need to go into length. In working with Ms. Stansel and Mr. Gardner, we came to this resolutions. The victims are in full agreement with it, and I would just ask the court to implement the agreement.
Is there restitution?
Your Honor, not at this time. I know that one of the named victims was looking into it, but I guess I would just ask to reserve restitution for 45 days in an abundance of caution.
I can't do that. I can find that there is a pecuniary loss and set a hearing to determine what that dollar amount is at a later date.
Your Honor, at this point, I'm not going to ask for that. We've had ample
No,
time. I've
do
asked
it.
the victim to put those documents together. I have not had a response. So I think we can just proceed without that.
We'll find no pecuniary loss, order no restitution. Mr. Gardner?
Your Honor, I know the court knows the facts of this case, so I won't repeat it. I know Mr. McCaslin didn't mention this. We would ask to waive fees and costs, any fines. He is serving, that Adams County sentence that he's serving is significant longer than the
Hold on,
sentence that he'll be
Violet.
serving on this
Hold
case
on.
as well. We just asked for 1,790 days of pre-sentence confinement.
No
Thank you.
objection.
Mr. McCaslin, you don't have to say anything. I'm happy to listen to whatever you'd like to tell me.
The last part that the attorney just said, the 1,790 days to be credited. And if, it could reflect to, I don't know, both mitimuses or however they do that. So DOC has no confusion on the time served. Other than that, I don't have anything to say.
Criminal attempt to commit murder in the first degree, I will sentence you to 16 years in the Department of Corrections, 5 years of mandatory parole. There is no fine. I will impose statutory costs and fees, 1,790 days of credit against that 16 years. That will run consecutively or one after the other to your sentence on count 2. Criminal attempt to commit murder in the first degree, a class 2 felony. There I'll sentence you to 16 years in the Department of Corrections, 5 years of mandatory parole. Minimus will reflect 1,790 days of pre-sentence confinement. There is no fine. I will impose statutory costs and fees. Both sentences on counts 1 and 2 will run concurrently or at the same time as your sentence in Adams County 21 CR 279. Counts 5 and 6 don't have a sentence associated with them because they're sentence enhancers. We should talk about the mandatory protection order that was entered on November 15, 2021. What is the people's position on the mandatory protection order?
And Your Honor, the named victims and the people would ask that remain in place.
Box number 7 is checked. Is there a nexus between alcohol and drug use and the facts in this case?
I know there was evidence that when Mr. McCaslin was taken into custody, there was evidence of drug use and alcohol use. I don't recall specifically any kind of evidence as to when these two incidents occurred, someone commenting on that. So that's the best I can tell the court.
What's the defense position?
We take no position. We'll leave it for the court.
Based on the people's record, I will find that there is a sufficient nexus between the restriction and box number 7 that the defendant shall not possess or consume alcoholic beverages or controlled substances and the safety of the victims here. The mandatory protection order entered in county court on November 15, 2021 remains in full force and effect through the duration of your parole period, Mr. McCaslin. So as long as you are in the custody of the Department of Corrections and or on parole, the mandatory protection order remains in full force and effect. You're advised that violation of the protection order could result in misdemeanor charges for violation of a protection order, further conduct that constitutes intimidation or retaliation against a witness or victim could constitute felony charges for intimidation or retaliation. The trial that was set to begin on January 9, 2026 is vacated. We will cancel any writs that had been issued. I don't believe we had set a pretrial conference yet.
I don't believe so.
Does he have any active dependency and neglect matters?
No.
No active dependency and neglect matters. Mr. McCaslin, you're remanded to the custody of the Department of Corrections. Good luck, sir.
Thank you.
So, that Adams County case they were talking about, that this runs consecutive to, Monica, thanks for the cheers. He got 192 years for. He has 192 years for that case. So this one meant absolutely nothing. He will never ever step foot outside of jail ever again. Brown Zoo, you made it. Oh, I'm so sorry. I should have read your whole comment before I was smiling and waving. I'm sorry you're going to a funeral. That sucks. But at least you're not in jail for 192 years. It kind of feels like it though when you're at a funeral, doesn't it? Feels like you're in a forever sentence. Bye,
Thank you,
Mr.
Your Honor.
McCaslin. See you
Turn
never.
to the Spanish language interpreter matter.
Yes, the Spanish matter is number 26 on your honor's docket, Melissa Hernandez Diaz.
26 is 25 CR 5713, People versus Melissa Hernandez Diaz.
She's approaching the podium, assisted by the Spanish language interpreter.
Me too. Good morning. Amelia Sapp on behalf of the people.
Good morning, Ms. Sapp.
Thank you.
Mr. Weber here on behalf of Ms. Hernandez Diaz.
I don't
Good
know
morning.
Miss Sapp. I don't know her.
Let's grab this case number.
We are using the services of the Spanish language interpreter. Are you able to understand what we're saying in English through his interpretation into Spanish?
Yes.
Mr. Weber.
Thank you, Judge. Set for arraignment. I'm taking this case over from Ms. Pernankel, asking for a continued arraignment. We have an office conference set up next week. I would ask for something in front of your honor.
Oh, she's baked, all right.
Mid to late January. I do need to investigate any collateral consequences as well as meet with her and review discovery.
Ms. Sapp.
All right, so we're set for arraignment today.
Yes.
All right, I don't object to another arraignment to the end of January or early February is fine.
22nd, 23rd, 29, 30.
I would prefer the 29th or 30th, just so I can make sure I do my due diligence.
29.
That's fine.
Your cash bonds in this matter continue for arraignment, January 29, 2026, 8:30 a.m. What else?
Nothing from defense. Thank you, Judge.
We need to set up we need to start a business all together, guys. Because it'll take all of us working together to start this new business. Think about it. This will be huge. Huge. This will be humongously huge. All right. We create this business that for a substantial fee, 5,000, 10,000, 20,000. We will remove you from the life that you are currently in and install you in a completely different life. Sort of like protection, witness protection, but not. So, like, we will have a home ready for you. We will have a job ready for you. You just owe us you just owe us $20,000, and we will install you in a whole new life somewhere. You just pick where. So what we have to do is, first we have to buy, like, let's just start small, 3 houses somewhere in the United States. Let's stay in the United States because I don't know how international business works. And then we have to also own 3 businesses in that state, okay? Because we have to install them in a job. But it's okay because they're each going to pay us $20,000. And then we can, use that money to buy a 4th house and 4th business. And then it'll just keep spiraling upwards. We'll all be billionaires, and we'll own all these houses and all these businesses. It'll just take time. This is a slow burn. First step, we have to buy 3 houses and 3 businesses that we have employees for. So someone take the lead on this and run with it, and we'll all be billionaires. Takes money to make money.
Thank you.
Thank you, Ms. Hernandez-Diaz. Is anyone else in Spanish?
Number 59.
No, it's not a pyramid scheme. We don't have to go find
59
2
Michael
people.
Schwartz.
Oh, actually, I'm wrong
And
on
they
that. It's
find 2
57.
people.
57.
But we could do that too. We could do a pyramid scheme. We could start it though, so we're at the top. So we're fine. No, we're providing a service. We are taking someone out of their life where it's dead end and they are just at the end of it. And all they have to do is save money. And we will just lift them out of that life, put them in a new life. Here's your new house. Here's your new dog. You work 3 blocks down the street. Now give me $20,000 and you can forget all of your old life. I like it.
57 is 25 CR 5871, People versus Sanson Sanchez Sierra.
And Sam Hamowitz for the people.
Byron Miller, 35166 for the defendant.
Good morning, Mr. Miller. Good morning, Mr. Sanchez Sierra. We're using the services of the Spanish language interpreter. Are you able to understand what we're saying in English through his interpretation into Spanish?
Yes.
Mr. Miller.
Yes, Judge. In discussions with the people, one of the issues is to resolve this, maybe restitution.
Whoa.
I'm being told that may take some.
What the heck? How did we commit fraud and tax evasion all of a sudden? What did we do wrong? I don't think there's anything illegal about what I just said. It's not, because businesses do it all of the time. They headhunt certain executives and they set them up in a house and a new job, and then they give him money. But I can't see anything illegal with this. I think a large amount of people would just want to start over, clean, get me out of this house, get me out of this city, get me out of this job, get me into another job, just get me out of here. And they can't do it because it's so hard.
Some time to come up with a proposal for that, so I'm asking for a 60-day set over.
Mr. Hamowitz.
But what do you mean?
No objection from the people.
What do you mean the IRS catches up with them? What? Why aren't they paying taxes? Of course they'll pay taxes. Everybody pays taxes. They're not gonna. That's not. In no way am I breaking the law. I have way better ideas if we're gonna break the law, guys. But this is completely legal. There's nothing illegal, immoral, unethical about this.
the issue of restitution is going to be the only real issue I think the parties face right now.
How is Thursday, February 12th?
Yes, I can accept that.
Morning or afternoon?
Afternoon.
Mr. Himowitz?
That works for the people. Thank you.
Your cash bond and this matter continue for arraignment Thursday, February 12th, 2026, 1:30 p.m. What else?
That's all.
Nothing from the people.
Thank you, sir. Anyone else in Spanish? Ms. Aria?
Good morning, Your Honor. May we
Morning.
please call number 11 and 12 on the court's docket?
Number 11 is 24 CR 6326. Number 12, 25 CR 4990. People versus Daryl Duffy.
Sam Hamowitz for the people.
There is some underlying shenanigans involved because they give us $20,000, we give them a house, we give them a job. They actually do have to pay for that house. They have to pay us for the house that we give them, but they can because they have the new job. But let's say they don't pay us. They're evicted and they're fired, they're evicted, they're out of there, but we still keep the $20,000 for our hard work. So we get paid for the house over years. We get to $20,000, that stays with us.
Christina Sri on behalf of Mr. Duffy. He's approaching. He appears on bond this morning.
Good morning, Mr. Duffy. Here, arraignment in one, revo status in the other.
Your Honor, at this time, we would waive further reading or advisement, enter a not guilty plea in the new law violation, and ask to continue to trail the revocation allegation.
Mr. Duffy, I will accept your not guilty plea in 25 CR 4990. Speedy trial is June 18, 2026. 21 days for motions. Does that work?
Yes.
21 days for the filing of any motions. Your first best options are January 22nd and 23rd. Actually, I cannot, 23rd would be in the morning for hearing. 22nd could be in the morning or afternoon.
One moment. Would we be setting this for dispo and motions? Okay.
One on Thursday, the one on Thursday for disposition, morning or afternoon. Motions would have to be in the morning on Friday. We could also do the 29 and 30, morning, afternoon on either day.
That sucks. 1 week
Is
off
that
for a
enough time for you to
C-section?
Look at everything.
That's plenty of time.
Okay,
Yeah.
that works. The 22nd and the 23rd.
Continue your PR bond for disposition January 22nd, 2026, 8:30. For motions if necessary, Friday, January 23rd, 2026, 8:30 in the morning. The revocation matter will trail. Your PR bond in that case continues to January 22nd, 2026. What else?
Nothing from the people. Thank you.
Nothing from defense. Oh, I would just make a record. Previously in the county court, Judge Rodarte issued an order for an SDT that was returnable previously. The Circle K tendered the surveillance to me or to my investigator. I forgot or lost track. I have officially tendered the SDT materials to the prosecution this morning. I just want to make a record on that.
Was the SDT return date in county court?
No, it was in the first arraignment date in district court. But either way, I conferred with the prosecution, and I think per the SDT, I don't think the court needs a copy of the materials. I just wanted to make the record that I have tendered them to the DA.
Anything there?
No, Your Honor.
Thank you.
Thanks.
Thank you, Mr. Duffy.
In the hallway, I want to talk to you about.
Does he have an appointment with his probation officer?
Mhm.
You should report to that.
He's reporting, yes.
Thank you.
And Your Honor, may I call number 77, the add-on matter?
No, you can't call an add-on matter because that's only going to take a minute and it's stupid. All right, guys, we made it to the end of the docket. We got to see someone go to jail for 192 years today. Thank you so much for coming out. I really appreciate it. Go make Friday great so that you're ready for the weekend. And I will talk to you soon. I'll talk to you tomorrow. Well, no. I'm going to set up OJ, so I'll talk to some of you really soon. Bye, guys. Thanks.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's